Are you getting on? Is it showing you? Are you waiting on me?
Yeah, it says commission.
There you go. All right. We're all.
Good morning.
Morning.
All right. This is 0032735 2019. It's Christy Lowry versus Richard Allen Logan, I believe. And I think we're here on is it a plaintiff's motion to strike affidavits?
It is, Your Honor.
Okay. Is that it? That's all we're here on?
Correct. As far as I believe.
Yeah, in my response, I requested leave for the to file them based on his timing argument.
Okay.
So
I saw, I mean, I've read everything. It showed that I guess the affidavits were struck or were filed late. And then it has some other arguments based upon
Notice and basis. Yes, sir. Yes, sir.
yeah. Okay. You can offer whatever you wish to offer at this point.
Judge, I'm happy to get into as much of this as you want. I don't have anything outside of what we have already submitted to the court. If you just want me to kind of, encapsulate the arguments, I'm happy to do so. Frankly, I think the fact that they are late probably precludes us from needing to get into any of the other arguments. But if the court feels like we need to, I'm happy to address as much as is necessary. I just don't want to waste anybody's time.
Yeah. I mean, the fact they're late, that reason alone is a reason to strike them. Because they've requested leave, I guess that we probably ought to get into the issue of.
In that, yeah, and I'll be happy to address that, Judge. In their response, which was filed this week, 3 days ago, they basically make the complaint or the argument that they should be excused and allowed to file this late because of COVID, more or less. The problem with that is a couple fold. In their paperwork, they claim that they miscalendared when this was due based upon the mistaken assumption that we had filed this case more recently than September of 2019, when in fact it was filed in August of 2019. Therefore, the old rules apply. Under the old rules, they're grossly late. They admit that they're grossly late under the old rules. They claim, and this is where I've got a real problem here. They claim that it was, and I'm quoting page 5, second full paragraph on the page, where they state it was discovered during this transition period that the date calendared for the controverting deadline was mistakenly input pursuant to 1801 cases filed on or after September 1st, 2019. The problem with that, Judge, is if that's a true statement, if that is a genuine statement, then that strongly implies that they discovered that around June the 27th of 2020. which was a full 205 days before they filed their motion for leave of the court to file this late. They never gave us any indication that they knew that this was late until January 18th of 2021, 205 days after these things were due, and many months after they just hauled off and filed their controverting affidavits without leave of court. They're not doing this in the right order, and I don't think there is any possible way that can be a genuine, true statement that this was discovered sometime around June, but they don't wait until January to ask for leave.
I think they're very late. I mean, I don't think that's the basis for them being late. I think that y'all just realized it since the trial date supposedly is coming up. I've read it all. The issues that were raised about the cash basis and the lack of notice based upon the controverting affidavits. That's probably what I want to deal with more.
I'm happy to visit on that. Both of these doctors do the exact same thing. They act like charge and the final negotiated amount that a provider will accept are interchangeable, and they are not. These doctors themselves charge one amount and accept many varied amounts based upon either their contractual relationship they have with Blue Cross or Aetna, or fill in the blank, any number of entities that get involved in this process. Or if they don't have any of those things and they have a cash payer in front of them, they have a different schedule of what they will accept from that person. But it doesn't change what is a reasonable charge. A reasonable charge is what the retail price is up front. Has nothing at all to do in 1801 with what a physician may be willing to accept whenever he's short and the IRS is coming due and he's got he's $500 short on what his quarterly taxes are. He may take a totally different figure at that date and time than what his charge was. And that's not what 1801 is about. It's about, was this a reasonable charge in this geographic location? They have brought forth no evidence related to the charges in this region. They have tried to tell us, in Vaughn's case, he just says, based upon the fact that I've been doing this a long time, y'all ought to believe me when I say they've overcharged, they shouldn't have done this, they shouldn't have done that. He provides nothing other than his own word on which to base it. And the case law is very clear. That's Ipsy Dixit. You can't just base it upon, I've been doing this a long time, believe me. The other doctor, who they say in their response has got all this experience and we ought to be able to just believe him based upon his tons of experience, he's been in Texas less than 3 years. His experience is on the East Coast and in France, which has about as much to do with the cost of the value of services and the reasonable charge of services in Collin County, Texas, as I know about combs and hairbrushes. It's ludicrous. One has nothing to do with the other. The reality is they have attempted to do what they have done in so many other cases. They're trying to pull a fast one here and equate what someone might finally accept in final payment of their bill, and equating that as if that is the same thing as a reasonable charge, and they're just apples and oranges, Your Honor.
Does a defendant have any response to all that?
Yeah, just outside of or adding to my responses, it is what it is on the timing. It got miscalendared based on the new rules. This case was filed earlier on before the new rule was in place. My client was served long after the case was filed and citation was given and everything like that. And that's kind of the issue that it got mistakenly calendared. It wasn't due to any conscious indifference. It was just a mistake and we seek leave for. There's no on that issue. There's no surprise. There's no prejudice that would be done to the plaintiff in this case. The trial. They when you talk about the timing, they knew that about the timiness of the counter affidavit months ago as well. So they knew about it. They could have taken steps filed a motion to strike back in September when we filed it as well. So that argument that regarding the timing and when they filed and things like that, it goes both ways. There's no surprise, no prejudice based on that. The trial date is approaching, but the due to COVID, jury trials have been being postponed. So there's no real prejudice. They still have other avenues to take with regards to addressing experts in the affidavits and things like that. To the basis, they've done what is required as far as providing a reasonable basis. They don't just say this is what I charge or this is what I would accept. They give a basis. They base it on because the 1801 covers reasonable cost and necessity. They do it in the cost. What would be a usual reasonable cost in the geographical area? And then also based on they charge the wrong CPT code. So it's not just that's an additional basis that they are providing. It's not just I would charge, in this case with Dr. saying I would charge $398. No, he's basing it based on what the CPT code is charged to. So one is he charged more for the CP code that was charged, plus he upcharged the CPT code from a 9 to a 99205 when it should have been a 99204, based on the medical records and the evaluation that was done based on the objective and subjective complaints that were made. So it's more than just this is what I would charge. He provides a reasonable basis based on that, which is what this is procedural about. It's purely procedural. The uncontroverted affidavits would have sufficient evidence, but it's not conclusory still on those issues, to where now they've given a reasonable basis that if they were going to cross-examine Dr. Sang and Dr. Vaughn, they would know what to cross-examine them on. That's a reasonable basis, and it's not just this is what I charge and just take it. They give a basis. It's based on the CPT codes. It's based on CMS, American Medical Association. That's what it's based on. And 3 years is long enough to develop a knowledge of charges in a geographical area. So just because you practice in this area for 3 years doesn't mean he doesn't know what the reasonable costs are being charged. And then, yeah.
Go ahead.
And then just on the cash basis argument, as I stated in the motion, plaintiff had health insurance, but she didn't use it. So she can't say I'm using my health insurance and stuff like that because she hadn't used it up to this point, and likely treated on the LLP where she hadn't even produced her health insurance. So to say that she's not a cash paying patient is disingenuous in this case because she hadn't even submitted her insurance based on those contracted what the reimbursements would be.
Cash and insurance are completely different things.
Right. But she's not using insurance or cash. So they're telling you what the cash basis would be and also what it would be for if you submitted insurance which is based on CMS and the multipliers and things like that. Still, it's a reasonable basis. And it's given the reasonable notice of what they're basing their opinions as to the reasonable cost and the necessity of the treatment is.
And LOP is about as far from a cash payer as it gets. Council just acknowledged we're not cash payers, and that's the basis they're using, which again is not what 1801 contemplates. They're talking cash basis on final payments, not reasonable charge. That's not the standard.
Well, I've read it all. I believe that that the cash pay basis is a problem. I believe that the timing of it's a problem. And I don't believe these controversy affidavits comply with 18.001. So I'm going to strike each of the controversy affidavits. And I'll sign the order that was submitted for that purpose. All right.
Yeah.
Thank
you,
y'all.
Art.
Good luck.
Thanks, guys.
Appreciate-
Thanks, everybody. Appreciate y'all.
Have a good.